Water Committee will come to order, please. We have a big day today. We are honored today to have with us once again Professor Griggs from the Washburn University Law School, specializes in water law, and he's agreed to come back and give us talking about the water laws in other states to see where we fall, what kind of laws we have. Professor Griggs, if you would, please.
Thank you, Representative. I trust you can hear me okay.
We can, loud and clear.
Okay, thank you. I appreciate the return invitation to testify before this committee. As my students and my own family know, I can talk about water law until everyone feigns death and I eventually leave the room, having picked up on the hint. I got my testimony to you yesterday. I doubt that as busy as you are during the session, you've had a time to look at it. So what I'd like to do is summarize it a little more extensively than I did in my January testimony, but I think I can get through that in 25 minutes at the most. And then we can go to the more important part of this meeting, which is your questions and our discussion. Representative Highland asked me to give an overview of the ways in which other Western states protect water rights. And so in doing, in fulfilling this request, I had to boil a lot of things down. And the way I did this is I started with the states that have our same doctrinal set of rules, that is the prior appropriation doctrine. And that is the general rule for most Western states, from Kansas all the way to California and up the coast. What's also important, though, is that prior appropriation doctrine has to extend to groundwater. And some states, most notably, or in Kansas's case, most infamously, such as Nebraska and California, Arizona, Texas, they don't follow the prior appropriation doctrine for groundwater. And that has caused these states all sorts of problems. We should be grateful that we don't have that problem. My first footnote is there, like all footnotes, for your entertainment. There are quotes here where the courts, often the Supreme Courts of the respective states, are essentially making apologies for their own water law, which they have the unfortunate duty to construe. So this rules out those states. The next criterion I used was jurisdiction. Where do states have a unified jurisdiction under one state engineer? And the third criterion really had to do with hydrology. Looking to states where groundwater is very important. Groundwater is obviously very important in Kansas. I understand that the groundwater management districts will be before your committee tomorrow. And so I looked to the states which had the prior appropriation doctrine for all their water supplies, which put jurisdiction under a state engineer, as we do in Kansas under the chief engineer, and finally had major groundwater supplies. And this, having applied these criteria, I kept coming back to the laws of Colorado, New Mexico, and Wyoming. This is also partially the case because our water laws in 1945 looked to these three states, especially those of Wyoming and Oregon. So I've also looked across the West to Idaho, Nevada, Oregon, Utah, and Washington. But as I say in my testimony, please, I'm not going to give you some endless survey of the water laws of each of these states. What I'd like to do is tell you some stories, some of the most telling and revealing stories across the West for how the state engineer, and just as importantly, state courts, have protected water rights over the last 30 or 40 years. So this moves me to section 2 of my testimony. What does the state protect when it protects a water right? Well, in my January testimony, I described the basic attributes of a water right: its priority, its authorized quantity, its point of diversion where it gets the water, its place of use where it uses the water, its type of use. For the most part, the attributes that are most commonly protected, where the owners seek the protection of the state and the courts, is the priority of the water right and the amount of the water diverted. I want to emphasize that in the prior appropriation doctrine, as we described in January, the senior right is entitled to all of the rights quantities before a junior right obtains anything. We do not share the shortage in the prior appropriation doctrine. So we protect water rights, but we also protect the water supplies upon which those water rights depend. And this is the balancing act that every state has to try and achieve every day of the year, but especially during irrigation season. And because water is a public resource, the state also has to balance public interests with private property rights. So with that, let me turn to the ways in which the other Western states protect water rights. The first thing I'd like to talk about is a term of art. It's called administration. When we talk about administering water rights, we are talking about a specific state action. We're talking about the state engineer shutting off or curtailing junior water rights so that senior water rights can obtain the water to which they are legally entitled. Under Kansas law, the chief engineer has the non-discretionary duty to protect rights according to priority. And that is right there in the first sentence of Kansas Stat Ann 82A 706B. The words shall in that sentence are taken very seriously by the chief engineer and the chief engineer's staff. It shall be unlawful for any person to prevent by diversion or otherwise any waters of the state of Kansas from moving to a person having a prior right to use the same. Upon notice, upon making a determination of that unlawful diversion, the chief engineer shall administer junior water rights. I will leave it to Chief Engineer Lewis and other experienced water veterans at DWR, such as Mr. Lane Letourneau, Chris Badel, and others, who could speak to the specifics of how Kansas has administered water rights. But what I'd like to do is tell you a couple stories about major administrations across the West over the last 20 years. The first one has to do with the South Platte River and Arkansas River basins in Colorado. And I may get the pronunciation of that second river wrong because I grew up in Denver. And when I cross the state line, I always make enemies. If I'm in Colorado, I call it Arkansas. And when I'm in Kansas, I call it Arkansas. So I apologize. You think this is funny, maybe it is, but as a Supreme Court trivia, when Kansas and Colorado were making oral argument before the Supreme Court of the United States in our suit over the Ark River, the two counsel of record pronounced the river differently, and Chief Justice Rehnquist had to intervene and explain that both pronunciations were perfectly appropriate. Of course, when you're arguing in front of the Supreme Court, you're generally dealing with 9 Eastern lawyers who aren't that concerned about water, and they don't really know what it is, except that it's really humid in Washington, D.C. There's hope, though. Justice Gorsuch is a Colorado judge. before he was elevated, and he's quite knowledgeable about water matters. In Colorado, there was a very serious drought on the Eastern Plains. This was also felt in Western Kansas in 2000 and 2001. The South Platte River, which is the location of the oldest water rights in the state of Colorado, as Colorado pioneers were moving across what was then Kansas territory, I might add, up the South Platte, they started claiming water rights during the 1860s and the 1870s, well before statehood. But the South Platte and then the Arc, the flows reached such critical levels, they began to make what we call a call on the river. They sought the assistance of the division engineer, which is similar to our water commissioners here in Kansas, and asked the division engineers to begin administering water rights in priority. That is, they requested the protection of their senior property rights. As a consequence of this call on the river, over 1,000 rights were administered during those summers. And that is a massive undertaking that required all hands on deck, going down the ditch riders of the irrigation ditches on the South Platte and the Arc. And they were able to do that. There was some litigation in the wake of that decision, but the state engineer's actions survived, and they survived for a very simple reason. As I point out in my testimony, when you administer water rights according to priority, you are not taking somebody's water. You are not committing a taking under either the Kansas or the federal constitutions. If all of you in the committee room today are junior to Representative Highland, and the stream starts getting dry and Representative Highland calls for his water rights, and you are shut down as a result, the government has not taken your water. That's because it is an express condition of every prior appropriation right that it is only a right to use water, and it is not a guarantee of water. So if the water is not available for your priority, then you have no takings claim. And I want to emphasize that because oftentimes you will hear actions by the state engineer across the West to administer water rights by priority as a governmental taking. And I've cited the standard case for this out of Colorado, the Cabobel case, that goes into that discussion in depth. The second example comes from Idaho, and this is in the Snake River Basin, an amazing geological formation in which a lot of snow and rainfall, a lot of water flows through the ground for miles and then can emerge later in springs. And so the hydrological connection between groundwater and surface water is very important in Idaho. Senior surface rights, again, requested an administration of priorities in the Snake River Basin. And the Idaho equivalent of the chief engineer initially refused based on the grounds that he did not have the authority to do so unless it was demonstrated that shutting down groundwater rights would be effective in providing water to surface rights. The senior holders sued, and the trial court found that the agency, the Division of Water Resources for Idaho, owed them a clear legal duty to distribute water under the prior appropriation doctrine. And I quote from the decision there, "The director's duty is clear and executive. The director executes the laws of the state of Idaho. Although the details of the performance of the duty are left to the director's discretion, the director has that duty." And that language could almost be word for word out of the Kansas statutes in terms of this non-discretionary duty. The chief engineer of the state of Kansas is a highly trained, experienced water rights professional. we owe the chief engineer and we grant the chief engineer a fair amount of discretion in how the water right is protected, but the duty to protect is not discretionary. These are not small actions, representatives. We are dealing with thousands of water rights in the South Platte and the Ark Rivers, thousands of water rights in Idaho, in the Snake River Basin adjudication. That one proceeding adjudicated about 450,000 water rights over the space of 15 years. So these are very big decisions. They are often politically difficult decisions, and it's an important job protecting property rights. And that's why many state engineers across the West enjoy substantial civil service protections. When a state engineer attempts to step in and protect water rights, and the political forces eject the state engineer, that often exposes the state to considerable liability. And a good example of that is the director of the Nebraska Department of Natural Resources, Dr. Ann Bleed, prepared to shut down groundwater wells in the Republican River Basin that were impairing stream flows to which Kansas was entitled. She was removed from her position. Shortly thereafter, Kansas sued, and we obtained a finding from the Supreme Court of the United States that Nebraska had to provide those stream flows to Kansas. That's administration. I could go on, but I want to move on to the other ways in which we protect water rights. As I mentioned in my January testimony, the state engineer protects water rights by reviewing applications for new water rights and by reviewing applications for changes to water rights. I described the Hayes and Russell transfer briefly in January. There are two similar stories, one from Colorado and one from Nevada. The Colorado story arises in the San Luis Valley, a high mountain valley that irrigates a lot of cereal crops. Coors beer gets a lot of its barley from the San Luis Valley, for example. So in the 1990s, a water speculator sought to move about 200,000 acre feet of water from the San Luis Valley and pipe it over the mountains and sell it mostly to the city of Aurora and other suburbs. Local irrigators protested, and the water court found that moving that water would have harmed the irrigators under the Colorado statutes. And so the water court found and denied that application. The Supreme Court of the state of Colorado affirmed the decision. A more recent example involves the city of Las Vegas. The city of Las Vegas, its main water agency, the Southern Nevada Water Authority, filed 145 separate water right applications to groundwater basins about 300 miles north of Las Vegas. They were seeking to divert, and that is not a typo, between 190,000 and 800,000 acre feet of water, to move it 300 miles south and use it for municipal use. Over 830 water rights holders filed protests. We call those people protestants. Don't say Protestants. This is not about Protestants and Catholics. It's about people who protest a water rights application. So it's okay, for example, if you're a Mormon, if you're the presiding bishop of the Church of Latter-day Saints, you can be a Protestant. There are no theological issues there at all. This is an interesting story. The first time it went to the state engineer granted the Southern Nevada Water Authority about 80,000 acre feet of water. And if you have ever driven through White Pine County on Highway 50, it's hard to find any water there. The state engineer found that water based on a formula that he and his office had developed, emphasizing the concept of beneficial use. If the water is there, darn it, we need to put it to use. The protestants sued, and a district court judge in White Pine County reversed, denied the applications, and the second time around, after the judge remanded the case back to the state agency, the new state engineer returned to the existing way in which we grant water rights in Nevada and denied the applications. Again, the city of Las Vegas sued, wanting more water, and the same judge, Judge Estes, no relation to Representative Estes, said Nevada law cannot be clearer. The rule is to ensure that basins from which water is taken and put to beneficial use will not be depleted and can be sustained in perpetuity. So here you have a state judge in a rural part of Nevada standing up to by far the most powerful single governmental agency in the state of Nevada, the Southern Nevada Water Authority, denying an effort to move water south to Las Vegas because the water is not available. That really drives home the importance of judicial review, which I'll turn to in about 5 or 10 minutes. Southern Nevada Water Authority did not appeal the decision. They've decided to get their water from the bottom of Lake Mead, as I point out in my testimony. The last thing in which the state, the last area in which the state protects water rights as an administrative reviewing organization is through public interest review, and that's because water is a public resource. That raises a really slippery question, though. Just what is the public interest? During the first 3 or 4 decades of the 20th century, public interest basically meant the protection of prior rights, but also questions of economic efficiency. If a water right applicant was seeking to divert water in a very, very wasteful way, where it may have taken the diversion of an entire stream just to get 1/10 of that stream flow to a farm, then a state engineer could say that's not an efficient use of water. Other people can use that other 90 parts of water that you're not using, so we're going to deny that application. In California, for example, in the San Joaquin Valley, it used to be in the public interest to use water in the winter to drown gophers. Well, in a pretty famous decision in 1935, and I quoted it, I cited it in the footnotes, the California Supreme Court held that that is no longer a reasonable use of water, that is no longer in the public interest. So what we view to be in the public interest more recently has had to do with how the world of water has changed. The onset of modern environmental law in the 1970s, with the Clean Water Act, with the Endangered Species Act, the importance of protecting Native American tribes who began to assert and get the water rights to which they were entitled in the 1960s and 70s. Also the importance of recreational use. Colorado's recreational economy now produces more money for the state than its agricultural economy. As a result, recreational uses of water have become more economically valuable. So what we talk about as the public interest is not a fixed thing. We define it in statute in certain areas of Kansas law, but it is a moving concept. And this brings me to section 4 of my testimony. What agency procedures across the West are there to protect water rights? Well, one of the things that states do is they enact regulations. And in this regard, most Western states have administrative procedures that are quite similar to Kansas. When the Division of Water Resources at the Department of Agriculture wants to draft and enact new regulations, it follows the pattern of notice and comment rulemaking. The state attorney general's office reviews the regulations to make sure they are legally sound and constitutional. And there is feedback from stakeholders. And finally, the regulations are enacted. And the enactment of regulations is very important because Kansas water law, I think I may have said this in late January, is like an iceberg. The statutes are the portion of the iceberg above the surface. But 6/7 or 7/8 of the actual rules are in the regs, and those are below the surface. And so the state agencies and stakeholders work all the time on drafting these regulations. But I want to point out that oftentimes these regulations can be subject to agency capture. And a good example of this has to do with groundwater pumpers in the Ark River Valley in the 1970s. In 1973, the Colorado state engineer approved rules for groundwater pumping, but those rules actually led to the expansion of pumping in the basin. One of the highlights of our 270-day trial against Colorado in our Ark River case was when our lawyers were able to get the Colorado state engineer to admit on the stand that the rules that were intended, or at least appeared to limit groundwater pumping, had led to an increase in pumping. In the wake of our victory against Colorado in that case, pumping in the Ark River Basin is limited to 15,000 acre-feet annually. Pumping has been reduced in that part of the basin by about 50%. So again, the importance of courts in protecting water rights, in this case, water rights held by the state of Kansas. But if you move across the state line, the same issue of agency capture has existed in Kansas. And in this, I'm drawing on an article written by Michael Ramsey, who, in my opinion, is one of the finest water lawyers in the state. It's based in Garden City. And in his article, which I have cited there in footnote 24, he describes how local regulations drafted by GMD3 involved a depletion formula for granting new water rights, tolerating the granting of new water rights as long as they didn't deplete the aquifer too fast over a 40-year period. But as Mr. Ramsey said in his article, this formula led to an open throttle on aquifer mining. And GMD3 has since changed that formula to its credit. It's a formula that was applied across the West. It's not unique to Kansas. But groundwater districts across the state, New Mexico and Colorado, have realized that those formulas did not protect the aquifer. They ended up accelerating its decline. And that raises a very politically uncomfortable question, but one that I think is absolutely necessary for the legislature and for this committee to ask. Are Kansas groundwater management districts fulfilling their intended role to conserve the state's water resources? This is a question that many in the state have asked for years. My mentor, Professor John Peck at the University of Kansas School of Law, described the problem in a question. Are the GMDs playing the role of the fox guarding the chicken house? He asked that question 15 years ago, and as I write in my testimony, in my opinion, I agree with Professor Peck that a candid conversation about the strengths and the weaknesses, about the achievements and the failures of the GMDs is long overdue. The power of the GMDs the power of large water users. In Nevada, the Southern Nevada Water Authority. In California, major irrigation interests. Underscores the importance of the independence of the state water engineer. Equally important, however, is the importance of judicial review. In Kansas, when the chief water engineer makes a decision, his most common decisions involve new water rights, changes to existing water rights, sometimes the abandonment of water rights, although that happens very rarely. Those decisions are subject to administrative review by the Secretary of Agriculture, who has no training in water, who does not have to be a water resources engineer, and serves at the discretion of the governor of the state of Kansas. Beyond that, there is judicial review under the Kansas Judicial Review Act, KJRA. And under Kansas administrative law, generally speaking, the record of the chief engineer's decision is limited to what happened at the agency level. But I'd like to flag what has happened in two of our most sophisticated states in water. The state of New Mexico, which is a poor, largely rural state, and the state of Colorado, which is a far wealthier, largely urban state. Prior appropriation states with different demographics, different industries and economics, they have both placed exceptional powers on the court system to allow what we call de novo review. And that is allowing a court to review an agency decision independent of what the administrative record was, including the power to find facts. New Mexico, as I say in my testimony, even amended its constitution to allow this in 1967. So what you may have seen in my January testimony and my testimony today is how Western states began to confront a lot of these issues in the 1960s and the 1970s. They did it for a very straightforward reason, because the problem of groundwater depletion was becoming known, apparent, and it was beginning to harm existing, long-established water rights. In New Mexico, their system is similar to ours. There is a hearing in front of the state engineer, and then that decision can be appealed to the New Mexico courts, which has de novo review. Colorado has its own water court system, and this was established under the Water Rights and Determination Act of 1969. An important piece of legislation the Colorado General Assembly enacted after a sustained study by prominent Colorado water engineers, led by Ken Wright of Wright Water Engineers and many Colorado lawyers. And I'm not recommending this system, but I think it's useful to think about. Colorado divides its 7 major river basins into districts. So for example, the South Platte is District 1, the Ark is District 2, and so on. And water rights matters are heard before the water clerk and the water referee, and ultimately a district court judge who is serving as a water judge. If the water court's decision is not satisfactory to the parties, and it will be shocking to have you hear that it often is not, then those decisions are appealed to the water judge and ultimately and immediately to the Colorado Supreme Court. Montana also has a water court system. The reason I'm talking about this is because when we think about the protection of water rights, it's not just the state engineer. It is also the way in which the courts police the actions of the state engineer as an officer within the executive branch of government. The fact that New Mexico and Colorado both established heightened powers of review over water issues during the late 1960s, I think merits reflection and some consideration. Both states made these fundamental changes to their procedures for sound reasons, grounded in concerns about separation of powers. They did not want to delegate too much authority to a state administrative agency under the executive branch at the expense of the legislative and the judicial branches. So wrapping up before we go to questions, Western states take the protection of property rights very seriously. And it's not just because they are dedicated public servants. It's because if you don't protect property rights, you are going to get burned. At some point, you will be running afoul of our robust state and federal constitutional protections against the taking of water rights and against the excessive regulation of property rights. As I've put forth in this testimony, state water engineers have administered thousands of water rights in one summer across the West. State courts have denied efforts to transfer hundreds of thousands of acre-feet of water. Given the importance of these decisions, judges and state water engineers have important protections under the law. In some states, as I said just now, have gone so far as to grant courts the power of de novo review. And with that, I will stop reading from what you may be reading along with me. I'm happy to entertain questions for as long as you'd like. Thank you.
Thank you. Tremendous amount of information to digest and think about. I'll start off with one question. We've talked about senior water rights, but between the states, did Kansas have senior water rights against Colorado and Nebraska? How's that work?
That's a good question. In our litigation against Nebraska, we were protecting rights that had been secured to Kansas under the Republican River Compact of 1943. So that compact granted the state of Kansas an allocation of the waters of the Republican River Basin. So the priority of the rights of Kansas was not really an issue in that case. There have been cases that the Supreme Court has decided based on priority. The most famous would be Wyoming v. Colorado in 1922, when the Supreme Court of the United States effectively said Wyoming follows the prior appropriation doctrine, Colorado follows the prior appropriation doctrine, so we are going to allocate the waters of the Laramie and the North Platte River according to their priorities as if that state line did not exist. That decision in 1922 terrified states across the West, especially the Rocky Mountain states, for a very simple reason, Representative Highland. It's because California had the oldest, most senior water rights in the West. And if California were to sue Colorado or New Mexico or Utah or Arizona, any of the states in the Colorado River Basin, they could obtain water rights by priority. This drove, during the 1930s and the 1940s, the negotiation of interstate compacts. So under a compact, the states agreed to a particular portion of the river's water supplies, both surface and groundwater. And so the issue of priority, thankfully, was not an issue in Kansas v. Nebraska because we had a compact to enforce.
But the Colorado one then?
Yes.
we have a compact with Colorado, or how was that?
We have two compacts with Colorado. We have the Arkansas River Compact, which we approved in 1948 and Congress approved in 1949. After 40 years of litigation, which started in 1902. And under that compact, Colorado is entitled to a certain amount of the Ark River supplies, and Kansas is as well. The respective priorities and the history of use of Western Kansas irrigators from, Finney County West played an important role in securing our allocations. Colorado is also a party to the Republican River Compact because the South Fork of the Republican River originates in northeastern Colorado, just north of Burlington.
Great, thank you very much for that. Representative Bishop.
Thank you, Mr. Chairman. I'd like to follow up on exactly that, having to do with pollution or the content in the water as it comes from Colorado. We were told of the situation with, as I recall, it's uranium, and that it was at least in part to account for the farming practices on the Colorado side. And the compact, as it appears, does not address that. Where does pollution interest or issues enter into this?
That's a good question, Representative. And I'd refer you to part of what we talked about in late January when Representative Jennings asked the line of questions about this. I'm happy to try and explain it better this time around. The Ark River Compact is a pretty old compact. It's 1943. That's 30 years before the Clean Water Act, 30 years before the Clean Air Act, the Endangered Species Act. It is a compact that predates modern water pollution legislation. So Colorado uses as much water as it legally can up to the wall, up to the last drop. By the time water reaches the state of Kansas and the Ark River, it's probably been put to beneficial use between 8 and 10 times. And as you mentioned, it picks up naturally occurring heavy metals, uranium, selenium, and other really nasty toxic metals. Under Article 4D of the Ark River Compact, Kansas is entitled to its allocation, and Colorado cannot materially deplete the waters of the Ark River Basin beyond its compact allocations. One of the prime reasons for the compact, like all Western compacts, is the principle of beneficial use. So if Kansas farmers, in the Amazon ditch or the farmer's ditch or the frontier ditch cannot put that water to beneficial use because it's too filthy, then you do have, arguably, I want to emphasize arguably, I think we on the Kansas side would look on the positive side of that, a violation of the compact. Colorado would disagree. They would say this is purely a water quantity compact. It is not a water quality compact. For example, we have a compact with Nebraska on the Big Blue River, which does speak to water quality. That compact was enacted in the mid-1960s when we were developing a modern consciousness about the importance of water quality. The Ark River Compact has never been amended, and good luck amending it, okay? It's that important. And so Colorado would say, look, you've got a 1949 compact. It is federal law. It is an act of Congress because Congress approves our interstate compacts. It's a state law in Colorado. It's a state law in Kansas, and it's federal law. There's no mention of the word water quality in the compact. We have the Environmental Protection Agency. We have the Clean Water Act. And that federal jurisdiction over water quality is where the issue of uranium and selenium lie. This is an arguable point. For example, when we sued Nebraska for the first time in 1998, Nebraska pointed to the Republican River Compact and said, we don't see the word groundwater in the Republican River Compact. That means we can pump groundwater. It's outside the jurisdiction of the compact. And the court disagreed. The court's special master, who is the trial judge appointed by the court to hear these matters, basically said, look, to the extent that groundwater pumping affects surface flows, that's part of the compact. Could you make a similar argument with water quality? You could. But Representative, I think that's a tough question given how we regulate water quality in this country under the Clean Water Act. And I think Tom Stiles may have been to this committee to talk about those issues. It's an important question though. And I would conclude my answer by saying, if we cannot put that water to beneficial use, that is a very serious problem, and we should be raising that with the state of Colorado.
Mr. Chairman, if I might have one brief follow-up. Can it be productively, positively affected by federal legislation, changes in federal law?
Yes, it could be. There are numerous examples of federal agencies spending large amounts of money and devoting their engineering expertise to addressing water quality issues across the West. The Rio Grande Basin, which is subject to a compact between Colorado, New Mexico, and Texas, is a basin where we could turn for water quality issues. And apparently this may be a priority under the Biden administration. Secretary Holland, who was approved yesterday, has made water quality an important issue. The Army Corps of Engineers, obviously part of the Department of Defense, not the Department of the Interior. They also have a large presence across the West basins. So I think there is room for the compact administrations of the Western states. In this case, the Arkansas River Compact Administration, perhaps to jointly seek federal assistance to address some of these water quality issues.
Thank you, sir. And thank you, Mr. Chairman. That was very enlightening.
Thank you. Representative Vaughn.
Thank you, Mr. Chair. And thank you, Professor Griggs. This was a really great presentation again. I was wondering, it sounds like you've maybe thought about this a little bit. So I was wondering what it might take to establish a water court in Kansas, and as a point of comparison, how that would change the existing judicial review process.
Representative Vaughn, I've thought about that, but not in any way that I could give you a satisfactory answer. Under the existing Kansas system, there are two ways in which we can bring expertise to bear on these water issues, similar to a water court. One is under the existing Water Appropriation Act, a district court can refer a matter to the Division of Water Resources. So let's say you and I are in a water dispute on the Arkansas River. We both divert water from the Ark River and we're in some sort of fight. So you sue me in Hamilton or Finney County Court. What I can do and what you can do under the Water Appropriation Act is request DWR to come in and provide technical assistance. That happened in a prominent recent decision, Garrettson Brothers v. American Warrior, in which the Division of Water Resources issued a report about how a junior water right was impairing a senior water right. So that procedure is there. Another procedure, Representative Vaughn, is the concept of a special master. The court can appoint a special master under state law, similar to how they appoint a special master under the Supreme Court's original jurisdiction, someone who is trained in matters of water law. That is not frequently done for a very good reason. Why do you want to pay a special master when your tax dollars pay for a district court judge? I would like to see more special masters out there. I can think of two who would be outstanding. One is Professor Peck. I'm volunteering him. I'm sure he's going to call me after this and chew me out. He would be extraordinarily capable, as would Lee Rolfs, who was the longtime senior counsel to the chief engineer here in Kansas. He is also retired, so I'm losing two friends with this volunteering. These people are out there. Mr. Ramsey, if he had the time, I think he'd rather go work on his ranch than practice law. So, but to answer your question more obediently, a water court could be set up, especially in matters that come up all the time, with groundwater disputes and with issues on our most contested basins out west. I think that could be done, but it's a conversation that, if we wanted to do that, I don't have any immediate prescriptions. I think that would be a cooperative conversation. How would we work through this? But I like the way you think, because to emphasize what I said in my testimony, it's not just the substantive protections of water law, the prior appropriation doctrine, the no injury rule. It's also the procedural protections. And that's why I'm attracted to this concept of de novo review by existing courts. That's an excellent question, Representative.
Thank you, Professor Griggs. That provided a lot of great context. I appreciate it. And thank you, Mr. Chair.
You're welcome. Representative Vaughn.
Thank you, Mr. Griggs. I'm a little confused on first and right, first in time, and balancing that with the public interest.
Okay. The public interest review occurs when the state is deciding whether to grant a new water right. Public interest review does not occur when the state is protecting rights in the setting of a dry stream of administering water rights. When it is time to protect water rights in times of shortage, the public interest review is not an issue. That issue has been dealt with when the state decided to grant or not to grant a water right.
Okay, thank you. Thank you, Mr. Chair.
Any other questions from the committee, both in-house and out in the virtual world? I see none. Professor Griggs, thank you very much. This was both enlightening, informative, and great stuff. We'll be in touch to discuss some of these items in more detail. You have a great day.
You too, thanks.
Committee, that's all we have for today, so we are adjourned.